Diego. I'm a litigator. I focus on commercial litigation, all various kinds, from intellectual property, breach of contract, partnership disputes, um, uh, general types of commercial litigation. With me today is Kyle Strong.
Thanks, Sean. I'm Kyle Strong. I'm general counsel with Collins Aerospace. I support our interiors business. And for those of you who are not familiar with our company, we do basically everything on an aircraft that you fly on from tip to tail. And the business that I support right now, if you walk inside an aircraft and you see the overhead bins, the seating, the galleys, and all that stuff, and even the labs. I never thought when I was in law school I would be supporting a business that has to do with toilets on an airplane, but here I am. So nice to be with you today.
And the topic today is effective dispute resolution, when to litigate versus arbitrate. And we're going to talk about some of the issues with litigation and arbitration and pros and cons and distinctions. Just general agenda today is the framework of each. We'll also briefly touch on mediation, which can be an additional alternative dispute resolution process that can work with either or. Arbitration clause enforceability in two types of contexts, particularly employment and consumer. There's some special rules that apply in those contexts. There's two main statutes, the California Arbitration Act and the Federal Arbitration Act, and there's a few differences there. There's some issues with class action waivers. A lot of companies try to impose those, especially in the consumer context. A couple of recent arbitration case spotlights we'll touch on, some international arbitration issues, and a couple of early resolution and drafting tips, and then some tips for general counsel. So getting started, selecting the forum, some issues to consider. Key business drivers: speed, cost, precedent, privacy, predictability. Kyle, are those things you consider when considering whether to arbitrate versus litigate?
Yeah, absolutely, Sean. So for our industry, we typically deal, with a lot of companies internationally, and most of the companies that we deal with, including here in the United States, tend to be what you would call national champions, and they're not the kind of companies that you want to be in a public dispute with. So for us, arbitration is definitely the preferred method for resolving disputes, because we're less likely, I should say, to be in the news when we're having a dispute with, say, a Rolls Royce of the UK. And in our industry, having to resort to formal legal proceedings to resolve disputes can harm your reputation in the eyes of your customers, because you can be seen as not willing to support an aircraft program. And so for us, arbitration is definitely a preferred method for resolving disputes. And then, Sean, as you mentioned, just talking about, we can talk a little bit more about it later, but the different venues for arbitrating and resolving disputes around the world are something that we take into consideration when we're drafting those clauses.
Absolutely. And I think we'll hit that on some later slides specifically. And I know you've got experience with some of the more popular international areas.
Yeah.
On the litigation side, I don't know if Collins ranks this as a priority, but injunctive relief, maybe in the IP field, I know a lot of companies do prioritize that, but that's something that might be considered on the litigation side that you would prioritize. Is that something you guys look at in trademark enforcement or patent enforcement? Or?
Yes, we typically carve that out from what you would call a mandatory arbitration clause, and for us, it's not uncommon to have IP disputes tied up with a commercial dispute or even some antitrust issues, and we've had some of those cases, and so it's been important to be able to avail ourselves of that equitable type of relief.
And then there's always mediation, which a lot of clauses have as a precursor to arbitration or even litigation, or you can always, since it's a voluntary process by agreement, you know, participate that at any point during the litigation or arbitration. Is that something you mentioned right before we got on here, an interesting scenario where you reached a resolution through a unique meeting, but is that mediation something you find valuable and something that you use a lot, whether it's litigation or arbitration?
We do. I've had some really good success stories with mediation. I think the thing that's important for us as general counsel and in-house counsel is making sure that you establish the right expectations with your clients, and also having a relationship with your counterpart is important too, because when it comes to mediation, I think there's a tension there between it can be a very effective way to bring the parties together to resolve disputes, to allow the parties to step into each other's shoes, so to speak, and understand where their counterpart is coming from. But if both parties are not committed to and authorized to resolve the dispute at a mediation, the drawback of it is you're paying someone a lot of money to babysit you, and it can be a waste of time and money. But I've found it to be incredibly successful. We had one mediation years ago where the CEO for my business and his counterpart had never sat down in the same room together, and we had this very elaborate get to know you session where we arranged a dinner. It was actually in Paris at a restaurant. We didn't intend for this, but it was called the Peace Cafe, and the rule was no shop talk. And they were able to get to know each other, and we had a very effective neutral who facilitated a 2-day session where our respective leaders were able to exchange views in the presence of counsel, and we were able to get it done. So it was a very effective way to resolve our dispute that had been going on for years. And it really just came down to allowing two people who were decision makers to get to know one another and understand where they were coming from.
Well, interesting resolution. So just touching on the distinctions a little bit more. So with litigation, we talked about the injunction. Also, when you're looking for authoritative precedent, but something not mentioned here is both appellate rights and evidence code. When you're in court, you're going to have to be considering how to get evidence admitted. I don't know your experience with arbitration, but it tends to be what evidence code. Everything gets admitted. Arbitrators tend to play kind of fast and loose with the evidence code. At least that's my experience. I don't know if that's yours. So if you're concerned about the admissibility of evidence, maybe arbitration's your way to go.
Yeah, I mean, for us, what I've found in the 5 or 6 big arbitrations that I've been a part of, the parties have essentially been able to tailor their own rules of evidence and their own rules for resolving their own procedural rules. Even though it's generally understood that there are some governing rules that apply, my experience has been that in some cases where the parties have been able to have a meeting of the minds, have been able to tailor those rules in a way that fits them. So again, when you look at this relative to litigation from our perspective, there's just a lot more flexibility and customization that you can achieve through arbitration.
And on that point, you're going to get a lot more personal attention in arbitration. I mean, you're paying the arbitrator to pay attention to your case, but when you're litigating, you're using your tax dollars to pay the judge, and they're pretty strapped, especially if you're in Superior Court. I think the last statistic I heard, at least in San Diego County, was they have something on the order of 1,500 cases, civil cases on an independent calendar docket. So really, when you go in there, they don't even remember who you are or what case you're on. So that's different when you're paying an arbitrator, an hourly rate to pay attention to your case.
Yeah, and then I think the other thing here that you have on here, Sean, is just needing expert neutrals. I mean, for us in our industry, it can be challenging at times to find triers of fact who can get up to speed quickly on the issues that we tend to deal with. We're very similar, surprisingly, to construction when you think about the process for designing and developing aircraft parts. It's very similar to construction and type in terms of the issues that we have, but it's there's no shortage of experts who understand the issues that we deal with in the aerospace and defense industry. And so again, we had I was mentioning this when we were preparing for this, but we had an issue in Italy years ago where we were seeking specific performance in aid of an arbitration. We had a supplier who was intransigent and literally threatening to throw our tools out in the street. We were trying to facilitate a transfer to another third party, and we hired an expert in Italy who literally wrote the book on civil procedure in Italian courts, and we were seeking specific performance in the Tribunal of Rome in aid of our arbitration, and we got in front of a judge who was very junior, and that person told us to just work it out amongst ourselves. And you can imagine the kind of conversation we had to have with our clients who we told all along, trust us, we're going to follow this process and everything should work out. And at that moment, you realize all the remedies and things that you learn about in law school and hear from trusted outside counsel fail to come to fruition. And then you are having a difficult conversation with your clients as to why it didn't work out. So again, that was as a result of getting in front of a judge who just didn't understand the issues and wasn't willing to rule against their home team in Italy.
Yeah, you get hometown of it.
Yeah.
It's mentioned at the outset that in employment context, there's some specific requirements if you're drafting a clause, and in California, that's Armandaris is the principal case. A couple of requirements that you have to look at is specifying that the arbitrator is neutral, so you don't just have the same arbitrator repeat player bias, that you allow for adequate discovery, statutory remedies are available, that you allow for a written reasoned award, the employer pays for the arbitration costs beyond the court fee, and that it's mutual, no one-way obligations. You can only require that one side's claims are arbitrated. In the consumer and commercial clauses, just a couple of the cases here. Concepcion was FAA preempts Discover Bank, which was California's judicial rule regarding unconscionability of class arbitration waivers in consumer contracts. This started the mass arbitration era. McGill and Citibank, public injunctive relief claims can stay in court. Waiver of those is unenforceable. The Federal Arbitration Act did not preempt California public policy prohibiting credit card account agreements from waiving the right to seek public injunctive relief in any forum. And then Amex Italian Colors, reversing judicially created exception to FAA, invalidating class action waivers that required class members to incur prohibitive costs compelled to arbitration. So a few distinctions between the California and the federal arbitration acts. California governs arbitration seated in California and can apply to contracts even if the Federal Arbitration Act would also reach them. The Federal Arbitration Act applies to contracts involving interstate commerce and preempts conflicting state law. For a motion to compel or stay the case, in state court, under the California Act, court may refuse to compel if there's parallel litigation with third parties and it risks conflicting rulings under CCP 1281.2. In the federal act, there's no similar discretion. Section 4, it mandates the action be stayed and the case be compelled to arbitration. As far as a fee payment deadline, in the State Act, a failure to pay the fees within 30 days can be considered a material breach and waive the rights to compel. And there's a recent 25 case Sanders where the employer, I think, missed the deadline by 5 days, and the court said the employer waived the right to compel arbitration. It was remanded back to the state court. The employee was allowed to litigate. In the federal act, there's no statutory deadline. The rules of the provider govern. As far as disclosures go, in the state rule, there are broad mandatory disclosures. In ethics standards, there's no similar federal rule or statute. If you're seeking to vacate arbitration award under the California Act, there's broader grounds for relief. There's non-disclosure of the arbitrator disclosures and refusal to postpone as separate grounds. And the parties may actually contract for expanded merits review. Under the federal act, there's very narrow specified grounds: corruption, partiality, misconduct, excess powers. You can't contract for appellate merits review. And on appeals, orders granting, denying are immediately appealable. And under the federal act, it provides similar appeal rights, but only for denials of arbitration. Grants are interlocutory only. Mute. There you go. Thank you. Okay, for tips on drafting clauses here, Kyle, you might have some additional thoughts on these. Clear delegation clause. Who's going to decide some of the gateway issues, either the court or the arbitrator? Specify the cost allocation. You know, what types of discovery you might want, if it's different than what the provider's rules might apply. Appeal rights, if you want any, different than typically allowed. Select the rules, the seat language that the arbitration is going to be conducted in, if it's not going to be English or if it's going to be international, if you're dealing with other countries and parties. Carve outs for IP and injunctive relief, as you mentioned, you typically do. Mass arbitration savings clause, fee shift and cost advance provisions. Anything on those points or others you can think of, Kyle, that you typically would want to work into your clauses?
Well, what I would say, just Sean, about some of these is really be thinking about the practical aspect of this as well. I guess generally speaking, what I would say is the more specificity you have around all of these issues, the better. But my experience is you can wind up with a very robust arbitration or dispute resolution clause that can be more than a page long. And in my experience, that you can spend a lot of time negotiating that. And at some point, your business colleagues will question why we are spending so much time talking about what's going to happen if things go sideways. And so the struggle with having a really robust and detailed dispute resolution clause for alternative dispute resolution is that it can be a challenge to get all that in a contract. And so you have to kind of strike a balance between having enough to guide the parties in the event that they do need to resolve a dispute, but not to spend too much time negotiating that type of clause in the context of a negotiation, a commercial negotiation. I do, and I think we'll talk about the international aspect of this in a later slide, Sean, but, just specifying the seat of arbitration that has the most relevance to where the business is being conducted and the parties' domiciles. And then also I think that's what I would say is just be cognizant of perfection being the enemy of the good when you're drafting these things, because I've had some experiences where my business colleagues have questioned why we're spending so much time drafting these clauses, and you can explain why it's important, but I've seen some of these clauses extend beyond a page in length, and that can be a problem from just a business commercial standpoint.
Yeah, I'm shocked that they wouldn't just listen to lawyers and do everything we. No, I've had that experience as well, in the litigation context, being on the other side where um, defending a motion to compel arbitration, and there was a provision that required, I think it required 30 days of good faith negotiations followed by mediation before you could institute litigation or arbitration, and they failed to do that. And we got the case dismissed because they failed to meet a condition precedent in the contract to allege a breach. And so, careful what you wish for in your clause, as you just mentioned. If you're not complying with every term, you might prematurely tee up a dispute that's not ready or ripe. So yeah, you got to make sure the business folks are on the same page with the legal folks there. So
I think that's an excellent point. So a lot of these, what you call executive escalation clauses that have to be satisfied or exhausted before you can file a demand for arbitration or a lawsuit. My experience is you can have a really nice clause that lays out a 30-day period to resolve at the working level. And failing that, you escalate to the VP level. Failing that, you escalate to the CEO level. My experience has been that those clauses and those steps and that procedure is rarely followed to a T. And so you are highly likely to, despite your best efforts, not adhere to the procedure outlined in your own clause. And then so you got to be thinking about that. It doesn't mean you shouldn't try to negotiate something that's clear and precise, but just be aware and be cognizant that the likelihood that you're going to follow that, in my experience, is remote.
Yeah, I think that's a really good point. There's a couple of recent cases in the last year or two to touch on arbitration. The U.S. Supreme Court had a case last year, 24. Courts, not arbitrators, decide which of multiple conflicting contracts govern if parties didn't clearly delegate that issue. In that case, there was some Coinbase sweepstakes that clashed with the user agreement in a 9-0 case, affirmed Ninth Circuit, and the Federal Act severability didn't override the contract formation principles. The Ninth Circuit also in 24 held that mass arbitration protocol was unconscionable, and a motion to compel was denied, motion to compel arbitration. Their Ticketmaster terms forced consumers into a new ADR provider with confusing rules that favored them, and the court stressed fundamental fairness requirement. The Sanders case I mentioned earlier, where the employer missed the payment deadline by 5 days, and court said they waived their right to arbitrate under the California Act. And then Viking River is a Supreme Court case that held that the Federal Act preempts California rule barring division of PAGA claims. The individual PAGA claims must be arbitrated. And then later, a California Supreme Court case said where a plaintiff has filed a PAGA action comprised of individual and non-individual claims, in order compelling arbitration of the individual claims under Viking River does not strip the plaintiff of standing to litigate non-individual claims in court. So a little distinction there. All right, now I'm going to touch on some international arbitration, which I know you have a lot of experience with, Kyle. So international arbitration awards, as far as enforceability, if they're subject to the New York Convention, they're enforceable in 172 countries. Cross-border litigation, you have to get foreign judgments, often requires some cumbersome recognition, comedy proceedings, neutral form and language. Parties choose seat in arbitration, rules, language, arbitrators, often tri-national panel. In litigation, parties may be forced into one side's home court. You just mentioned Italy and your experience there and how that worked out. In the procedural laws, confidentiality in arbitration, it's generally private. Evidence rules are flexible, as we mentioned. In litigation, filings are presumptively public, at least in the US, and in discovery broad. Every country is different, of course. Speed and cost in arbitration is going to be typically faster than many national courts, probably could be costly, or at least upfront. And court fees in general in litigation are lower, but once you add in discovery and duration, could be longer. Who knows how it all shakes out in the end, and once you add in appeals and delays. So Kyle, I don't know if you have any further thoughts on this in comparison and additional.
Yeah. So just some drafting tips, Sean, and this might be duplicative to another slide, but we try to, if we're going to market, so to speak, in our standard terms, we'll have, if we're doing business through an affiliate that's based in Asia Pacific, or if we know that that is the most relevant place to resolve disputes, we'll specify. We have different placeholders in our standard terms for the person who's drafting and negotiating that agreement to select from. So if we're doing business in Asia Pacific, we'll specify Singapore International Arbitration. If we're doing business in Europe, Middle East, and Africa, we'll specify London Court of International Arbitration. If our general preference, obviously, is to resolve disputes in New York pursuant to either AAA or ICDR, sometimes when we're doing business with certain parties in continental Europe, they tend to favor ICC. I'm generally aware through our litigation department that ICC tends to be the most expensive of those. I don't know if anybody else has any similar thoughts on that, but we try to avoid ICC because it tends to be a little slower and costlier than other forms. But that's the approach we take, and we try to make it very efficient for our contracts and legal professionals who are kind of first chair on these negotiations to pick a clause that's already has some standard language in it relative to where we resolve disputes.
And you mentioned Singapore. It's becoming a more and more popular location to select for international disputes. I think I saw in the 25 survey, it was in the top 4 in many of the lists. And a lot of the reasons were that it follows a model law, a minimal intervention doctrine. It's got Singapore High Court, Court of Appeals enforce awards promptly, and statistics show it's very low set-aside rates. It's got very nice facilities there, the Maxwell Chambers facilities. I don't know if you've used those, but apparently they're very nice and new. English language proceedings, and the regional hub for Southeast Asia, India, as you mentioned, and some of the political turmoil in Hong Kong and mainland China sensitivities make it a lot more popular in recent years.
Yeah, it's funny. I mean, you could see it kind of coming around the corner 20 years ago. So I'm of a certain age now where I remember when I first started, it was Hong Kong International Arbitration Center was the preferred seat for arbitration in that area of the world, and it's come full circle now to Singapore 20 years later. You don't see, except when we're doing business in China. And in the more and more, we're seeing our Chinese counterparties specify courts in the People's Republic of China, and then negotiation becomes whether it's going to be that or resolving in Hong Kong. But generally speaking, throughout Asia Pacific now, we're seeing the vast majority of our disputes being resolved in Singapore.
As you mentioned, some of the times you want to recommend Singapore is the joint venture supply chain disputes in Asia, India, China, common law procedure, but neutral Asian venue, need for expedited rules or emergency arbitrator relief. And, some of the comparisons to other seats. London, as you mentioned, is still a top selection. I think it was #1 in the survey I mentioned. There's some issues there post-Brexit, I guess. And Hong Kong is dealing with some political situations now, and apparently Dubai is growing in popularity now. I don't know if you've utilized that at all.
We haven't, but I've been working on a JV in the UAE for the last 3 years. And what I'm going to say is going to be no surprise to anyone who's done business in that part of the world. But prior to 5 years ago, that was one of the parts of the world where I had not done business. And it was very eye-opening going over there. It's full of expats. Most of the legal professionals over there are from the UK. All the big UK firms are there. But I found myself at a negotiation table, a couple of years ago, and except for myself and a Jordanian, everybody at that table was from England, trained in English law and working in Dubai, Abu Dhabi at firms there. So that they have essentially imported that, several professional services, and that is, legal is one of them. And so I'm not an expert on all the intricacies of the nature of the law over there, but what I can tell you is it's heavily influenced by English law, as evidenced by the fact that the vast majority of attorneys who I've worked with over there are English.
Very interesting. Here's a clause you might use for selecting Singapore is just any dispute shall be referred to and finally resolved by arbitration administered by SIAC under SIAC rules. The seat of arbitration shall be Singapore. The language shall be English. You can include governing law separately under New York or English law. Substantive law neutrality is important. You mentioned earlier the negotiation ladder and whether to include it or not. This is sort of an example of that query, whether to include it or not. I mentioned the condition precedent issue. So depending, I guess, on your situation and how closely people pay attention to the details in their contracts, whether or not including it is a good idea or not is a case-by-case assessment, I suppose.
Well, yeah, and to your point, I mean, it can act as a double-edged sword, right? I mean, I feel like it's always good to explore mediation because it can be highly effective and can save the parties a lot of time and money in resolving disputes. But you can get tripped up by it if you specify it as mandatory, and then you skip that process because of certain exigencies associated with your matter.
Right. Just a few takeaway points. Make sure if you're drafting an employment agreement or arbitration clause applicable to your employees, does it meet Armendariz in California if you're dealing with California employees? If you're dealing with consumers, we addressed mass arbitration fee exposure? Are carve-outs aligned with our IP and injunction needs? Is the seat governing law optimal for enforcement? Are escalation steps and timelines built in? Are they likely to be met? If not, any condition precedent concerns? Anything else you can think of that we've talked about or maybe haven't talked about today?
Well, a couple of things. I think some folks might be wondering where they can find model clauses. I don't know, Sean, if Procopio has, a resource for that, but that would be from a practitioner's perspective is these are great points. Where can I find model language if you don't have them within your library? And then I think this is more of a general practitioner's guidance or recommendation, but my experience, and I say this, full disclosure, I probably spend 33% of my time on dispute resolution, although this year it's probably closer to 60%. But what I would say that is, I'm sure what I'm about to say resonates with a lot of people on this call, but it's so important to manage expectations with your clients when it comes to dispute resolution, whether it's litigation or arbitration. And that can take the form of whether to specify litigation or arbitration in your contracts. But I think more importantly is when it's time to go to the mat so to speak, and resolve disputes, and you've kind of exhausted your options in terms of being able to resolve them at the business level. It's so important that you make sure that your clients understand what expectations are going to be from them to support the process. My own experience has been a lot of my business clients think, oh, I couldn't resolve it with my counterpart. Shucks, I'll just hand it over to the lawyers and back to business. And I'm dealing with this case. I'm dealing with a case like this right now where I've had to disabuse a couple people on the notion that this is just going to be something that my colleagues and I handle. Instead, I've had to make sure they're under they're under no disillusion that they're going to be intimately involved in the process. They are going to have a second job, and they can like it or not like it, but that's how it's going to be. And they need to understand, their supervisors need to understand what's expected of them from a commitment standpoint. To I've had to explain to people what a custodian is, what it means to be a custodian, and what's expected of you as a custodian in terms of the amount of time and energy and calories, as we like to say, that you're going to spend with us, and that you're going to have to figure out how to do all of that in addition to your day job, and that there's no exceptions to the process. There's no excuses. So you're going to have to commit to doing this. And frankly, that's the price that you're going to pay for not being able to resolve this at the business level. So I know that sounds draconian and a little harsh, but if people don't understand what it takes from a time commitment to resolve these things, we as legal professionals can find ourselves in some very uncomfortable situations, having to explain to judges or arbitrators or mediators why we can't produce evidence that supports our position, and so on and so forth. So Sean, I don't know how much you've seen that. I happen to be supporting a business right now that's a little immature in that process, and we're dealing with certain challenges that are causing us to have to resolve a lot of disputes. And I'm finding that there's not that my clients are not used to having to do this. And so it's a big surprise. It's very eye-opening for them.
Had that conversation once or twice. Heard it's the principle of the matter once or twice, where you start out and they're, ready to go to the mat, and then you start talking about budgets and what's involved with litigation, and how long it's going to take, and there's no attorney fee clause, so you're going to have to pay your way, and that means at the end of the day a reduced recovery for you even if you win. There's a lot of things you got to consider, whether it's litigation or arbitration, and at the outset it's everybody's ready for the fight, but then after a few rounds they are ready to find the way out. So that's where I think early on when we mentioned mediation and where it fits in, whether it's litigation or arbitration, sometimes you're not ready for it at the front end, but maybe slot it in down the line once they're both bloodied and bruised a bit.
Yeah. I've got a friend who works in commercial real estate in Dallas, and he calls this process being tenderized. And sometimes I use that term to explain what is in front of us to our clients. But yeah, it's definitely something that not a lot of business people do have exposure to, and you really have to see yourself as a bit of a professor in terms of explaining how it all works. And I don't know how unique my company is. I suspect it's not unique in this area, but there are certain disputes where we as a legal department will handle the expense and absorb and pay for the attorney's fees. But there are other disputes where we do a charge back to the cost center for that particular business. And a lot of times clients are surprised to learn that they're actually going to pay for this. And to your point, Sean, that reduces any amount of recovery, or it causes them to look at the situation a little differently, where they may, as a matter of principle, not want to settle the matter because they're upset, but you have to talk in terms of cost of defense and say, hey, listen, we're going to spend $100,000, $200,000 to resolve this, whether we win or lose. So that money's going to be spent. and it's going to come out of your budget. And well, they say, well, I don't have it in my budget. I say, well, you got to find room, because that's how this works. And this isn't a dispute where the legal department pays for the attorney's fees. It's a dispute where the business does. And then you get to have those conversations. But it's really important that people understand up front, and they may not like the dialogue at the outset, but the worst position that we can be in as in-house counsel is to surprise the business down the line, where let's say a dispute runs for 6 months or a year, and you've racked up substantial fees, and then they realize midway through fourth quarter in 2025 that they're on the hook for $1 million that they weren't counting on, and all of a sudden that can become a big problem. And it's one thing for people to become upset about litigation and dispute resolution costs. It's another thing for them to be upset about it and it come as a surprise and prevent them from meeting their, sales or EBIT targets, I should say, for the year. That is a really bad spot to be in as in-house counsel. So it's always, we have this phrase in our company, I'm sure others do as well: bad news doesn't age well, and it's better to get the bad news out in the open up front than for it to percolate and fester.
Yeah, that's a great point. Sort of in closing here, I think we talked about some disputes that should never go to, or maybe typically don't go to arbitration, like IP, injunctive relief. Is there anything else you can think of that you would not want to go to arbitration?
In our industry, we have certain regulatory issues where you can have disputes around, that's the kind of thing that sometimes that would be the only examples that immediately spring to mind. I think in the labor and employment context, I'm not a labor and employment attorney. I'm involved in numerous L&E cases involving my business, but I'm not first chair on those. But those typically are not resolved through arbitration, in my experience.
Great. Well, appreciate your time, Kyle, and all your input. I don't know if we have questions from the audience. Audrey, if you're able to moderate those, or how we get those in.
I do not see any questions.
All right. Well, that I think we can conclude for the afternoon. Thanks for everybody for attending. Actually, we have one more slide for a couple more upcoming presentations on July 16th and July 30th. In-House Lawyer's Guide to E-Discovery and Data Preservation with Jacob Poorman, and Building a Winning Appeal Strategy, a guide for in-house counsel with Kendra Hall. So that, thank you, everybody. I think there was a question about where to find the slides. There is a link, I think, on the ACC website to find them. So appreciate everybody attending, and thank you, Kyle, again for your time. Thank you, Audrey.
Thanks, Sean.